What's up, guys? Brian Felfel Law Group PLLC here with your Florida Law Weekly Case Update. Got six-pack of cases for you. In my opinion, some super interesting cases this week. Let's get right to it. So the first case is out of the Florida Supreme Court, Brito versus Salas. This has to do with the perhaps common situation, I don't know, where somebody donates their sperm using an at-home sperm donation kit, essentially. I didn't know this, but apparently you can buy these at, like your local CVS or Walgreens. So essentially what happened here, a man and a lesbian couple arranged so that the man donates his sperm to one of the ladies and she impregnates herself. The lesbian couple eventually gets married. Then they split up. Later on, the man comes back and is trying to assert rights to the child. He wants to take care of the child. He wants to be involved in the child's life. He wants to be the dad. So, question is, did he automatically relinquish all of his rights by donating his sperm? Well, there's a statute at issue here, 742.14. Lower court, and this was Florida Supreme Court, so the lower court, the appellate court, found that he relinquished his rights by donating his sperm. Sperm donor was a broad term, and then he's basically giving up his sperm. So he did not satisfy any of the exceptions in the statute, like a commissioning couple, and he basically didn't satisfy any of the exceptions. So therefore, he donated his sperm, and that's it. He foregone all of his rights. So the appellate court, the Supreme Court said, no, not so fast, my friend. Actually, the statute really only applies to artificial reproductive technology in a lab, like in a laboratory setting. They did an extensive look at the history of the statute and compared it with other provisions, and essentially they ruled that that only applies if you're doing a sperm donation like in a laboratory setting, not the at-home kit. So big implications if your client or yourself or if you donate your sperm in one of those at-home kits, you don't necessarily relinquish all your rights. So you got to be super careful. If you want the sperm donor to actually relinquish their rights, make sure they either do it in a lab or do some sort of consents. Just document it very much so that the person relinquishes his rights, because he's not going to automatically relinquish them. That's the key. Next case is Jan versus Abinuman. This is an injunction case. This was actually interesting for two reasons. First of all, get this, okay? These were pro se's. So, pro se person sues their neighbor for an injunction, tries to get a stalking injunction or something like that, harassment injunction against their neighbor. Instead of granting the injunction that this person asked for, the court turns around and grants an injunction against the petitioner in favor of the respondent. Basically, like essentially sua sponte, perhaps, something like that. So obviously that seems like ridiculous and, a violation of due process, which the court said that it was. But here's the other thing. The person did not timely appeal. And they did not timely appeal the order denying their motion for rehearing. They didn't actually make an argument in their briefs, specifically arguing why the order denying their motion for rehearing reconsideration should be reversed. So because they did not timely appeal the initial order and they did not sufficiently address the other order, they're out of luck. So they got stuck. It seems like they got stuck with an injunction against themselves. This person files the injunction. Court says, no, I'm not granting your injunction. I'm actually going to enter an injunction against you. And because they did not timely appeal and they did this all pro se, they're out of luck, essentially. That's unfortunate. Next case is Webking versus Webking. This is a paternity case, has to do with payment of extracurricular activities and child support and being held in contempt. And the things that I thought were interesting were, number one, extracurricular activities. If the judgment does not specifically say, or the MSA, that extracurricular activities must be paid regardless of whether they're consented to, seems like the court is going to find that they must be consented to by the parties in order to trigger the obligation to repay their percentage share. So practice tip, if you're going to include this, make sure If you want the other side to be obligated to pay the extracurricular activities regardless of whether they consent, you got to specifically say that, because otherwise, you know, you're going to run into problems. I mean, you may even run into problems regardless here, because the parties have to consent to the extracurricular activities in order to trigger the reimbursement obligation. The other thing that was interesting about this case is a reminder: if you're doing a contempt order, you have to include, it's pursuant to the rule, you have to include specific findings of why the person had the ability to pay. You can't just say he had the ability to pay. You have to say how, from what source. You have to actually cite the facts that the trial court relied upon. Otherwise, it will get reversed. Next case is another interesting case, and I have to admit, this is I never knew this. I've been practicing since 2012 as a family law attorney. I never knew about this statute. 787.03 is a criminal statute. It makes it a crime in certain situations to interfere with somebody's child custody, and apparently it can actually apply to the parents. I never knew that. Look up the case law that cites that statute, which I did, and apparently there are some cases where you can, like for example, not this case. This case really, the specific case here was it was a short citation basically, but I had to look this up. But there are cases, for example, where somebody had supervised time sharing only, and they went around that, and they like picked up the child, took the child for ice cream, came back and dropped the child off. You know, no harm, no foul, right? No, they got charged criminally, and I think they spent multiple months in jail just for that, for violating 787.03. I actually also didn't know there's a cause of action in civil tort to sue a third party for interfering with child custody rights. So I would think normally the courts don't get involved in that. You know, they let the family court decide, and the prosecutor doesn't come by. But there is potentially that avenue apparently. Ortiz versus Sangalang is the next case. This has to do with absence of a transcript and citing things for the first time on appeal. So if you're going to appeal something, make sure, obviously, number one, you got to have that transcript. But number two, make sure you are only arguing things that were made an argument to the trial court in the first place. If you're arguing for the first time on appeal, most likely not going to be successful. That's what happened in this case. In the last case, Edwards versus Williams, this has to do with modifying a parenting plan. The court, this is pursuant to the old statute, the old version of 6113. The court used to have to find not only a substantial change in circumstances, and that it was material and best interest of the child, but also that it was unanticipated. No longer does the statute say that, but this case was traveling under that old statute. And so for that reason, they had to say it was unanticipated, and if you don't include that in the order, it's going to get reversed. Again, now that unanticipated language is gone, but make sure anything that's specifically required by the statute to be included in the order, make sure it's in the order, because otherwise you might get reversed on appeal. All right, guys, that's it for this week. I hope everybody enjoyed it. Hope you have a wonderful weekend. Great week. Take care.